Hello, good evening. I'm Errol Baptiste doing a news broadcast. London Borough of Ealing breaches 70 distinct rule of law on Care Act 2014. It is very true that the London Borough of Ealing committed a systematic breach of law across a broad spectrum of regulation, articulate in legal action and public notice as the 70 rule of law, breach through a continuous indefinite act, underscore the severe intersection of housing disrepair, information management, failures, and statutory social care neglect. In the case of Errol Baptiste, this spanned several critical decades and properties manifested in the following framework of statutory and regulatory breach. 1. The continue of intentional harm. 1997 to 2020, the 23 years illegal room let Mr. Baptiste was left in unlicensed private room measuring just 3.88 square meters. This fell drastically below the UK legal minimum standard outlined in the Housing Act 1985. 2020 to present, the Northolt Bungalow. After being moved to a council property in Northolt, he faced continued exposure to severe damp, peeling walls, mould and rodent infestation. This environment directly endangers his health as an individual living with chronic obstructive pulmonary disease COPD. 35 months plus of cognitive neglect, the failure to remedy these structural defects or address emergency housing complaint persistent indefinitely from November 2021 onwards. Core breaches under the Care Act 2014 and public law. While public arguments consolidate failures into the 70 distinct rules or standard violation, the statutory core rests heavily on the complete breakdown of integrated duty between Ealing Housing and adult social care directories. The system blindness omissions, section 9 and 11. Ealing Council failed to update internal information management system to log into Mr. Baptiste's intersectionary vulnerabilities, COP, autism, and OCD because this record were missing, ignored, unlawful care, and housing need assessment were fundamentally non-existent. The integration deficit, section 3. Adult social care and housing operate in a complete silos. Disconnecting directly result in the council refusing him temporary emergency accommodation as his physical and cognitive vulnerability were never cross-referenced or flagged during housing crises. Continuous safeguard failures. Section 42. Leaving a vulnerable resident in condition described by surveyors as a Victoria slum while fully aware of his medical condition, continuous act of intentional neglect and omissions of the statutory duty to safeguard adult from environmental harm. 3. Data protection and administrative failures. The continued act extended into systematic administrative misconduct which regulators use to establish severe fault. Information management breaches. By systematic neglecting to document personal care needs and health vulnerabilities on the operational database over multi-year breaches. Ealing Council breach section 45 and 94 of the Data Protection Act 2018 alongside Article 15 of the UK GDPR. Continuous Act extended over a period. Maladministration and deceit. The Housing Ombudsman issued a finding of severe maladministration against Ealing Council for its hostile, defensive, insensitive handling of the case. Rather executing its public duty, the borough mounted an unsuccessful judicial review in an attempt to challenge and overturn the Ombudsman finding. 4. Discriminatory and retaliatory legal acts. A critical pillar of the Continue Act argument involved the hostile legal measures taken against Mr. Baptiste when he documented disrepair, false criminal pretext. Ealing Council pursue false allegation of harassment against Mr. Baptiste. They explicit misinformed the Housing Ombudsman that he was involved in criminal behaviour. This legal strategy, by using improper motive, backfired entirely at Uxbridge Magistrate Court, where the prosecution offered no evidence on 22nd October 2024 resulted in his full acquittal. Protected characteristic violation. The continued failure to maintain the property pair with the aggressive court action is legally framed as institutional victimization under Section 149 of the Equality Act 2010, public sector equality duty, directly targeting a disabled black resident who was exercising his right to complain on the right to safe housing in this respect.